kinds of companies. What are the kinds of companies? There are three basic kinds: a one person company, a private company, or a public company. These are the three basic kinds. So let's first see one person company. In Companies Act section 2 clause 62, it is said that a company which has only one person as a member, okay, it is a one person company. It can be formed as a private company, okay. It has a distinct separate legal entity, okay. If there is a member and there is a company, both have separate entities, the company will have separate entity, okay. And due to its separate legal entity, the company will have its own assets and liabilities, okay. The promoter is not personally liable to repay the debts of company. If there are any debts of the company, then the promoter, he will not be personally liable to repay those debts. It will be the liability of the company. Nominee: the sole member has to mention a nominee while registering, okay. It is compulsory to mention a nominee at the time of registration. No perpetual succession on sole member's death, okay, will result in nominee choosing or rejecting to become member, okay. When the sole member, he dies, okay, then the nominee, he may either choose to become the member or he may reject to become a member. If he chooses to become a member, there will be perpetual succession, the company will go keep on, okay, it will be alive. Or if the nominee rejects to become a member, then the company ends there. There is no perpetual succession. There is no minimum paid up share capital requirement for a one person company. In a one person company, there is no requirement to hold annual general meetings. So this was a one person company. Now let's see what are private companies. In the Companies Act section 2 clause 68, it is said that a company which has minimum paid up capital of 1 lakh rupees or more as prescribed, okay, by its articles, it restricts the right to transfer its shares, if any, okay. If the company is limited by shares, if its capital is divided into shares, okay, then the shareholders, they cannot transfer those shares to another person. It prohibits invitation to public to subscribe to its shares debentures. In private company, the private company cannot invite public to subscribe to its shares, okay. Limits number of members to 200. The maximum number of members in a private company can be 200. What are public companies? In section 2 clause 71, it is said that company which is not a private company, the minimum paid up capital is rupees 5 lakh or such higher as prescribed. A public company is an association consisting of not less than 7 members. There should be minimum 7 members, okay. There is no limit on maximum number of members. There can be any number of members, okay. Maximum, minimum is 7, maximum, there is no limit. There is no restriction on transfer of shares. They are traded publicly. In private company, there was restriction on transfer of shares. In public company, there is no restriction. A public company can invite public to subscribe to its shares or debentures, okay. The name itself is public company, so it can invite the public to subscribe to its shares, and its shares are traded publicly. These companies can further be classified as, these companies may be called as follows: companies limited by shares, okay. If the capital of a company, it is divided into shares, okay, then these can be, private companies can also do it, public companies can also divide their capital into shares, okay. So in the event of winding up, when the company is dissolved or it comes to an end, the liability of the shareholder, it is limited to the extent of amount remaining unpaid on their shares, okay. If a person takes a share of a company, suppose that share amount is 100 rupees and he has paid 30 rupees and 70 rupees are remaining unpaid, okay. So in the event of winding up, his liability is limited to only 70 rupees which is unpaid. This is companies limited by shares. Companies limited by guarantee, okay, these can also be public or private companies, okay. In the event of winding up, in the event of ending of the company or dissolution of the company, the liability of the member is limited by the guarantee he has given, okay, for the assets. So the liability of member extends to the amount undertaken to be contributed by each of them towards the assets of the company. These companies can be share limited by share capital or not, may or may not have share capital, okay. If these are limited by share capital, in addition to guarantee amount, in addition to this amount, okay, in addition to the guarantee they have given, their liabilities also to the amount remaining unpaid on their shares. What are holding and subsidiary companies? These are relevant terms, okay. These are connected terms. A company is a holding company of other if other is its subsidiary, okay. If one company it is holding company, another company is subsidiary. Holding company is a holding company, okay, if it is as a subsidiary, okay. If it is a holding of company of subsidiary, and a subsidiary company is a subsidiary company if it is a subsidiary of a holding company. So this means, this is the meaning of relevant terms. These are interconnected to each other. If there is no subsidiary company, there will be no holding company. If there is no holding company, there will be no subsidiary company. A company would become subsidiary of another if that other company controls the composition of its board of directors. If this company controls the composition of the board of directors of this company, then this company will be the holding company. If the other company has the power to appoint or remove all or majority of directors without anyone's consent, if this company has the power to appoint or remove all or majority of directors of this company without taking anyone's consent, then this will be the holding company. That other company holds more than 50% of equity share capital or more than 50% of total voting rights, okay. So this was holding and subsidiary companies. What are government companies? In section 2 clause 45 it is said that in which minimum 51% of paid up capital is held by either central government or one or more state governments, or central government and one or more state governments, okay. The subsidiary of a government company is also a government company. Like there is a government company, it has a subsidiary, so this subsidiary will also be a government company. What are foreign companies? In section 2 clause 42 it is said that a company or body corporate which is incorporated or formed outside India and which has a place of business in India or conducts any business activity in India, these are foreign companies. What are multinational companies, MNCs? The companies that manage production or deliver services in more than one country, they are multinational companies like Tata Motors, L&T, IBM, Infosys. Then there are companies with charitable objects, not for profit. Section 8 empowers the central government to allow these companies to dispense with the word limited. The central government can allow these companies that the company need not add the word limited after their name, okay. They can allow this exception if provided to its satisfaction that these companies are promoting commerce, arts, science, religion, charity, or any other useful objects, okay. If the central government is satisfied that these companies are promoting commerce, arts, science, religion, charity, or any other useful object, then the central government can allow for it. The company prohibits payment of any dividend to its members, and the company apply profit or other income in promotion of its objects, okay. It applies its income and profit to these objects, charitable objects. Then there are investment companies. The explanation to section 185 says that the company whose principal business is acquisition of shares, stocks, debentures, or other securities, they are called investment companies. Then comes finance companies. Section 45 clause 1 subclause C, it says this section is of RBI Act, Reserve Bank of India Act, not Companies Act, okay. It is not Companies Act. This section is of RBI Act, okay. It says that non-banking company, which is a financial institution, is a finance company. What are its activities? They finance loans and advances. Okay, they provide loans and advances. Then they are involved in insurance business, etc. Companies regulated by special acts, like the banking company. Banking companies are regulated by Banking Companies Act. Insurance companies are regulated by Insurance Act, and there are Food Corporation Act, etc. Okay, so these companies are regulated by these special acts. The provisions of Companies Act apply to them insofar not inconsistent with the special act which constitutes them. Okay, the provisions of the Companies Act, they will apply on these companies if the provisions are in consistency with these special acts. If they are not consistent with these special acts, then those provisions will not apply on these companies. Okay, so these were kinds of companies. If you want the PDF for revision, you can get the download link from description or comment box. If you are interested, you can get it from there. Next will be private company, which we will see in next video.